Okay, everyone, we have done it. We have made it to the final part, part 9 of the full lawsuit readout, where the Idaho 4 victims' families are suing the Washington State University, where Brian Koberger was an employee and teaching assistant there. So let's get right back to where we left off, and we're going to wrap this up. WSU's response to Koberger's behavior and the numerous complaints raised by WSU students, faculty, and staff was clearly unreasonable. Title liability also arises when discrimination and harassment is so severe, pervasive, and objectively offensive that it deprives victims of access to educational opportunities or benefits. Koberger's discriminatory and harassing behavior was so extreme, pervasive, and objectively offensive that female classmates would flee the classroom in the middle of instruction, leaving their possessions behind. Female students, staff, and faculty felt threatened and scared by his aggressive staring, looming behind them and uncomfortably close, physically blocking their exit and following them to their vehicles, necessitating routine security escorts. The descendants, Kaylee, Madison, Xana, and Ethan, all students at a federally funded university in the same community, were also deprived of and permanently denied access to educational opportunities and benefits when Koberger stalked them, planned his attack, violently assaulted them, and ultimately took their lives. WSU's acts and omissions alleged herein with respect to the discriminatory, harassing, and stalking behavior of Koberger against multiple female students deprive students of the full benefits of their educational program on the basis of sex in violation of Title VI. WSU failed to exercise its supervisory power and disciplinary authority over Koberger despite having repeated notice of the high risk of serious misconduct. The likelihood of Koberger engaging in future and escalating misconduct was so obvious that WSU's failure to act was the result of deliberate indifference. WSU had the ability, but failed to take timely, appropriate, and decisive action that would have prevented the harassment, stalking, and unaliving of the descendants. WSU's acts and omissions alleged herein caused, in fact, and substantially contributed to the stalking, assault, and murder of descendants. WSU acted with deliberate indifference to known acts of harassing and stalking against female students in connection with its programs or activities that it was in a position to address appropriately, and therefore may be held liable for damages. The next count is negligence. The plaintiffs incorporate by reference each and every allegation stated above as if stated herein in full. WSU had a duty to exercise ordinary care and refrain from negligent acts and omissions, duties that arose out of a special relationship between Koberger and WSU under restatement of torts. WSU failed to exercise ordinary care in its special relationship with Koberger and was negligent. As Koberger's employer, WSU also had a duty to exercise reasonable care in hiring, supervising, and retaining Koberger as an employee. WSU was negligent in hiring, supervising, and retaining Koberger as an employee. WSU also had a duty to exercise reasonable care so as to control Koberger while acting outside the scope of his employment, so as to prevent him from intentionally harming others, under restatement of torts. WSU was negligent when it failed to control Koberger so as to prevent him from intentionally harming others. They also owed a duty of care under the restatement of torts where its affirmative acts create or expose someone to a recognizable high degree risk of harm through such misconduct, which a reasonable person would take into account. An act or an omission may be negligent if the actor realizes or should realize that it involves an unreasonable risk of harm to another through the conduct of the other or a third person, which isn't intended to cause harm even though such conduct is criminal. WSU was negligent by its own affirmative acts that created and exposed the descendants to the recognizable degree of risk of harm posed by Koberger. WSU's adaptation of Waiver 21 and TAP protocols heightens these duties, as these frameworks mandate proactive assessment and intervention for behaviors like threats or stalking, which align with known red flags in violence prevention, and caution against certain responses that can heighten the risk of violence. WSU had a duty to use reasonable care to control Koberger and protect members of the Pullman-Moscow community, including descendants, from foreseeable harm and the imminent danger that Koberger posed. As described in detail above, there was a definite, established, and continuing relationship between WSU and Koberger. The relationship between WSU and Koberger was unlike WSU's relationship with a typical individual student. WSU offered Koberger employment as a teaching assistant for a definitive period of time, the 2022 fall semester and 2023 spring semester, with defined and established expectations of performance and behavior pursuant to a written employment agreement. WSU affirmatively brought Koberger to the Pullman-Moscow community from the East Coast, and its offer of employment included a requirement that he reside in Washington. As a result of this agreement, WSU expected to receive teaching assistant services that benefited WSU undergraduate students and faculty. For instance, WSU policy provided that Koberger's primary duty was teaching, or serving as a teaching assistant, and he was required to, quote, be at work each normal workday, including periods when the university classes are not in session. In return for his teaching assistant services provided to WSU, Koberger received a salary, health benefits, on-campus office, housing, and tuition. Efforts that Koberger engaged in to identify the descendants' stalk and plan his attack that occurred in his on-campus office or on-campus housing or using WSU's resident internet network are activities occurring on WSU premises. As part of their relationship, WSU required Koberger to follow the graduate school policies and procedures manual, the WSU Department of Criminal Justice and Criminology Graduate Handbook, the Apartment Agreement, the Network Service Agreement, and the WSU Standards of Conduct, all of which applied to both on and off-campus conduct. WSU required that Koberger maintain high standards of professional and ethical conduct and to show respect for undergraduate students. WSU agreed to provide adequate supervision and training and specifically assigned WSU faculty to serve in that capacity with Koberger. Koberger engaged with his WSU supervisors on a nearly daily basis. WSU had the ability to control Koberger and in fact did exercise control over Koberger. WSU also knew of the necessity and opportunity to exercise control over Koberger. WSU had the ability to use its multidisciplinary TAT to conduct a threat assessment using its Waiver 21 protocol to identify Koberger's propensity to commit violence and to implement measures to mitigate that risk, but failed to do so. WSU had the ability to use its Center for Community Standards to investigate and enforce the numerous standards of conduct that Koberger repeatedly violated, but failed to do so. WSU had the ability to discipline Koberger or terminate his employment and defund him at any time if he engaged in misconduct, so had a deficient job performance or violated university policies, but failed to do so until after the unalivings. WSU was the entity solely responsible for ensuring that Koberger complied with the terms of the various WSU agreements, policies, and procedures that Koberger was bound to abide by. Interventions like monitoring or removal likely would have prevented the unalivings by breaking Koberger's access and momentum. Had WSU followed its policies and procedures, including but not limited to escalating complaints to a full Waiver 21 assessment and TAT review, it likely would have prevented escalation by triggering interventions including counseling, mental health referral, suspension, expulsion, or law enforcement referral, thereby averting the mass unalivings by removing Koberger from his position in the Pullman-Moscow community long before he committed the unalivings. Indeed, after the unalivings, WSU exercised the ultimate control over Koberger and terminated his employment, defunded him, and served him with a trespass admonition prohibiting his presence at WSU. WSU knew or should have known that Koberger habitually engaged in misconduct in a manner dangerous to others. WSU affirmatively mismanaged the numerous complaints that it received about Koberger's inappropriate behavior, including but not limited to attempts to contain those complaints within the Criminal Justice and Criminology program, avoiding escalating complaints to proper authorities, engaging in ineffective and informal discussions with Koberger, and affirmatively keeping him employed at WSU. Through its close relationship with Koberger, WSU had substantial insight into his dangerous propensities and was aware of the identities of various victims, primarily young female students. As undergraduate students living in the Pullman-Moscow community, Descendants were foreseeable targets and victims of Koberger. It was reasonably foreseeable to WSU that Koberger would engage in future and escalating misconduct and dangerous and predatory behavior, including violence, if action was not taken to mitigate that imminent threat. Had WSU's TAC conducted a proper Waiver 21 assessment and followed the recommendations and warnings of that threat assessment and intervention protocols, it would have known that Koberger was a ticking time bomb ready to explode and should not have embarrassed him in front of his entire cohort when it mandated remedial sexual harassment and discrimination training for all students, but solely because of Koberger's behavior. WSU is aware of Koberger's repeated instances of inappropriate, predatory, and menacing behavior occurring within days of him first appearing on the WSU campus, and WSU breached its duty of care and was negligent in one or more of the following respects: hiring Koberger and bringing him to the Pullman-Moscow community without conducting an adequate background check and other pre-employment vetting, failing to adequately train and supervise Koberger, failing to follow WSU policies and procedures, failing to timely report Koberger's inappropriate and menacing behavior to WSU's threat assessment team, and failing to perform an adequate threat assessment of Koberger and failing to implement necessary, proper, and urgent measures to mitigate the imminent threat posed by Koberger, failing to report Koberger's inappropriate and predatory behavior to appropriate WSU administrators and law enforcement, permitting the Criminal Justice and Criminology Department to address Koberger's behavior through informal, piecemeal, indecisive, and wholly inadequate faculty discussions and ad hoc, failing to timely report Koberger's inappropriate and menacing behavior to WSU's Center for Community Standards, and failing to promptly and thoroughly investigate such reports and take urgent action against Koberger, failing to timely report Koberger's inappropriate and menacing behavior to WSU's Compliance and Civil Rights Title Office, and failing to promptly and thoroughly investigate such reports and take urgent action against Koberger, failing to monitor Koberger's inappropriate use of WSU ResNet Internet Network and take appropriate and urgent remedial action, failing to enforce WSU policies and the rental agreement by failing to inspect Koberger's residence following reports of his harassing, stalking, and menacing behavior, and failing to enforce the rental agreement's prohibition of weapons on campus property and in on-campus housing, including the K-bar knife that Koberger used to assault and unalive the descendants, mismanaging the numerous complaints and reports of Koberger's inappropriate behavior, failing to intervene in Koberger's discriminatory, harassing, and stalking behavior, failing to discipline Koberger. Retaining Koberger as an employee of WSU follows numerous reports of his dangerous and alarming behaviors, beginning with the earliest days of his employment. Failing to terminate Koberger from employment with WSU, and failing to defund and remove him from campus. Failing to warn the Pullman-Moscow community of the danger and threat posed by Koberger. Placing the financial condition and reputation of WSU above the safety and security of the Pullman-Moscow community in general and the descendants in particular, and in other respects that may be revealed during discovery. If WSU had exercised reasonable care, Koberger would have been neutralized as a threat long before he committed the unalivings. WSU's negligence caused, in fact, and substantially contributed to the assault and unalivings of descendants. As a result of WSU's negligence, plaintiffs were damaged. Count 3 that they're charging for this is they are saying gross negligence. And they go on to say that WSU had a duty to exercise slight care, which is care substantially less than ordinary care, and to refrain from grossly negligent acts and omissions. WSU's multiple failures and breaches of its duties owed, as described above, proximately caused the assault and unalivings of descendants and resultant damages for which WSU is liable. The other count that they are suing against is outrage. WSU's acts and omission described herein constituted extreme and outrageous conduct that went beyond all possible bounds of decency and can only be regarded as atrocious and utterly intolerable in a civilized community. WSU acted either intentionally or with reckless disregard for the near certainty that emotional distress of some female students would result from WSU WSU's acts and omissions with regard to Koberger. WSU did in fact cause severe emotional distress to Platon's descendants and their families. Now, for each victim, for Madison, Kaylee, Ethan, and Xana, there are survival claims listed. Now, the wording is the same for all of them and those family members who are representing them. So I'm going to read through it once and just insert all of their names, because otherwise I'd be reading the same thing just with different names, just so you can understand the language that they're using in this lawsuit. These are the survival claims. The wrongful acts and neglect of WSU as alleged above caused or contributed to the injuries inflicted on Kaylee, Madison, Xana, and Ethan. Prior to their deaths, all four victims experienced extreme pain and suffering, anxiety, emotional distress, and humiliation as Koberger repeatedly and violently stabbed them to death. At the time of their death, none of the victims had no surviving spouse, domestic partner, or living child or stepchild. They do not have surviving. Oh, sorry. Well, this will specify, right, that Kaylee has surviving parents and siblings. So it'll describe if you have surviving parents or siblings. That's what they did for each one. And then it's going to describe who is the personal representative for each victim's estate. And that representative is asserting a survival claim for the pain and suffering, anxiety, emotional distress, and humiliation sustained as a result of each victim's injuries. The plaintiffs in the case are seeking damages in such amounts as determined by a trier of fact to be just under all the circumstances of the case. They include a wrongful death claim. The wrongful acts and neglect of WSU as alleged above caused or contributed to the death of all the victims. The personal representatives of the families assert a claim for wrongful death for the economic and non-economic damages sustained by the beneficiaries as a result of each victim's death, including but not limited to the loss of the descendants' love, guidance, companionship in society, services, care and attention, protection, and advice. The plaintiffs seek damages in such amounts as determined by a trier of fact to be just under the circumstances of this case. So again, the wording is the same for every family member that is involved in this case. It then goes on to say they have the reservation of rights. The plaintiff reserves the right to assert additional claims as may be appropriate following further investigation and discovery. Now they have the prayer for relief. Plaintiffs pray for judgment against defendant WSU as follows: for all special and general damages established at trial, for compensatory damages in an amount to be proved at trial, for plaintiffs' reasonable attorney's fees pursuant to the title and any other applicable law, for punitive damages as allowed by law, for prejudgment interest as allowed by law, for post-judgment interest as allowed by law, for an award to plaintiffs of the costs of this action, and for such other legal or equitable relief as the court deems just and proper. They then have a demand for a jury trial. Plaintiffs hereby demand a trial by jury on all matters so trialable. And that is the end of it. It's then signed, the 7th day of January, 2026 by, it's submitted by Wagstaff and Cartmel LLP. And there's some other attorneys here. I cannot say their names. There's a whole bunch of attorneys on this, but it's the Wagstaff and Cartmel. They're out of Kansas City. So that is the full lawsuit readout. That was 126 pages I read through and that you listened to. It really gives an overview of exactly what they're looking for. And you can see as well, wanting a trial by jury, of course, is something that would benefit them in this case. The other thing I think that they're seeking from this, besides anything monetary wise, is the information that would come from the discovery part of this and the further investigation that they want from WSU. So, I mean, let me know your thoughts on it. I'm just curious as to what you're thinking. Having read through it all out loud, is still processing. Also, as mentioned in part 1, I am suffering from a terrible spinal disc bulge, and I am still laying here in pain. But this is a lot of information, and all those agreements that are signed, they absolutely had a duty to protect students and didn't do anything about Burger. I don't know. To me, it's very clear. I don't see any confusion as to why nothing was done. And it's very common. Unfortunately, you see this where women go report issues and problems of stalking and harassment. And it's like they're not taken seriously, or just nothing. It's noted and filed and nothing is ever done about it. Something I've noticed a lot when I've covered cases has to do with the way I look at universities, colleges, and campuses now is totally different when, as a parent, as a mother, I look at wherever my child will want to be going to school in her future. Looking at the campus safety as a whole is a whole new perspective I have after covering true crime and the way you see campuses either do handle or don't handle things. If you have a child at this university, or you do attend this university, these would be things that would concern me as a student or as a family member. Let me know your thoughts on that as well. I just think some of these things you just would have no idea potentially are going on. These are scary things that were happening to women at that university that were consistently going for an education, yet they were being stalked, harassed, intimidated, couldn't sit comfortably in a classroom to learn. It's the basics that somebody should be able to go do that. A female should be able to do that. So yeah, let me know your thoughts. That's the final part of this lawsuit. I will keep you updated if there's anything else that comes out further. By them submitting this, I think more information will eventually trickle out because they want to do investigation and discovery. So that's going to make WSU have to put forth some more information, whether that's from the ResNet network that they have as well, or other filings that they may have had that are not public at this time. Thank you for being here. Make sure to hit that follow button and like. Give me a comment on your thoughts.